Let's bring in former top DOJ official Francey Hakes. Francey, your take on the Supreme Court will hear the Trump team's appeal of the Colorado ban on Trump, removing Trump from the state ballot. Your reaction to this breaking news?
Well, I'm not at all surprised, Liz. I'm certainly relieved and I'm happy because this is an issue that's obviously growing from state to state as states try to kick President Trump off the ballot in what is obviously an anti-democratic, un-American move by the Democrats. But I'm glad the Supreme Court's going to hear it on February 8th. We'll hear oral argument. We may even get a sense from the Supreme Court about how individual justices feel about the issue by their questions. So hopefully they will hear it. We'll get a sense of what they think, and they will rule fairly quickly and put a stop to these illegal maneuvers by the states.
Francey, we've got more news coming in. New York State Attorney General Letitia James now seeking a big $370 million in penalties from former President Trump and the Trump Organization in her civil fraud case. That's more than the $250 million she originally estimated. You know, this is coming ahead of next week's closing arguments in that case. What do you think of this, Francey?
Well, you know, Liz, it's really hard to understand this entire case. Generally, civil law is designed to either punish people who have done something wrong, like committed fraud, if it's a civil case, make the victim whole again, or in a criminal case, we know the purpose is to punish a perpetrator, but this is civil. And the supposed victims, the banks, testified that they weren't victimized at all, that there was no fraud. We had President Trump put up an expert who was a recognized expert who the judge somehow still disregarded and said that there was nothing wrong with the accounting that the Trump team was using. And so it's really hard to understand what the judge is going to stand on when he rules, as I don't doubt he will, as he rules for Letitia James and whatever she's asking for. I don't know whether he'll give her everything she's asking for, but it certainly won't surprise me given what I see as the kangaroo court proceedings that have taken place thus far in that courtroom.
So I'm going to ask the team to tee up Democrat Jamie Raskin's soundbite as we talk about this. Illinois voters, they're the latest state trying to remove Trump from their state ballot, citing the 14th Amendment on insurrection. We want you to listen to Democrat Congressman Jamie Raskin. He's joining former Speaker Nancy Pelosi. Apparently, neither of them read the full text of the Constitution, basically saying that, yeah, the states are allowed to remove Trump from state ballots. Watch this.
Well, the text of the Constitution is unambiguous. It's just perfectly clear. If you swore an oath to uphold and defend the Constitution and you violate that oath by engaging in insurrection or rebellion, you are never allowed to hold federal or state office again. So I guess my major question is, given the comprehensiveness and the airtight logic of the Colorado decision, why would there be any reason to depart from the clear text of the Constitution and from the original purposes? And I would pose that specifically to the so-called textualists and originalists on the court.
How about we pose to him why he clearly did not read the 14th Amendment? Francey, how does an elected official, a lawmaker, including Nancy Pelosi and now Jamie Raskin, not read the 14th Amendment? Again, Section 5 says Congress only has the power to enact a law to do anything remotely, like removing Trump from any state ballots. They didn't do that.
Well, you're right about that, Liz. Jamie Raskin needs his eyes checked because he clearly cannot read, and I don't know what state bar he's a member of, but he certainly shouldn't be calling himself a lawyer, as I know he does, or a former prosecutor, as he also does, because he clearly doesn't understand how to read the Constitution and how to understand the construction of the 14th Amendment, which is pretty clear. The president is not even listed in Clause 3 of the 14th Amendment. As you've noted, Congress has to promulgate the rules behind how to remove someone from the ballot under the 14th Amendment. So it's not clear to me, Liz, that any official in this country could be removed under the 14th Amendment, given the clear reading of the 5th section of the 14th Amendment. So Jamie Raskin can say all he wants, that it's very clear and great reasoning by the Colorado Supreme Court. But I expect the United States Supreme Court is going to slap down that shoddy piece of work that was that 200 pages of hot garbage from the Colorado Supreme Court.
Got it. Francey Hakes, thanks for joining us. Let's bring in for her reaction Senate Judiciary